why don't we get it going, yeah? All right, I'll just start with a few introductory words. So my name is Damon Haas. I'm the senior publisher at Emond Publishing. I've been at Emond for about 6 years, and for the most part, I've focused on commissioning works for the criminal and immigration bars. But when I come across an idea that is so timely and so important, one dealing with how litigation intersects with artificial intelligence, I feel compelled to publish it. This idea was brought to me by the great Jill Presser. I remember us meeting up for breakfast in the pre-COVID era, and she told me about the massive impact that AI will have on our legal system and how it will impact almost every area of practice, from administrative law to immigration, criminal law, torts, contracts, and that it will create challenges to our rules of evidence, notions of culpability, but also potential advantages in how lawyers practice law. So to be quite honest, after our discussion, I was both thoroughly intrigued and somewhat horrified. While AI offers tremendous potential for good, as we all know, it also comes with significant risks, evoking some of humanity's most dystopian fears. So then Jill told me about her friend Jesse Beetson, who was clerking at the time at the federal court, and how he was very knowledgeable on the potential of AI, and generally he was on the forefront of how technology interfaces with the law. So we imagined a book with a few enthusiastic, well-positioned lawyers who helmed the ship as general editors, and then we would seek out the most knowledgeable experts to author chapters on discrete subtopics. So after discussions with Jill and Jesse, we wanted one other general editor, and our short list was very short. It consisted of Gerald Chan. Already an author of mine, I was somewhat nervous about going back to him with yet another ask. Luckily, Jill and Jesse were able to convince him, as I suspect I may not have been able to. And with the general editor team in place, we were able to attach an impressive list of contributors, some of whom are in attendance tonight and we'll hear from later. So just generally, there's several different formats of the book that are available on our website. We're happy to offer a discount to all the attendees tonight. So you'll find the link to our catalog page and the discount code in the chat. Now I'd like to just introduce our three esteemed general editors. So first, we will start with Jill Presser. She is the principal lawyer at the law firm of Presser Barristers, where she practices primarily in appellate criminal defense, mental health law, digital privacy and digital rights, law and technology, including artificial intelligence, privacy, and surveillance. Jill regularly appears in courts at all levels, including the Supreme Court of Canada. Among her many accomplishments, from representing interveners at the Supreme Court or amicus curiae appointments and teaching at U of T, she is also the founding co-chair of the Criminal Law and Technology Committee of the CLA. Next up, Jesse Beetson. At one time a judicial law clerk at the federal court and legal counsel at the Ontario Superior Court of Justice, Jesse is currently a research lawyer at Norton Rose Fulbright LLP. Recently, Jesse worked as a consultant lawyer for Ontario's Long-Term Care COVID-19 Commission and for the Law Commission of Ontario. He has published and presented internationally and authored an award-winning article on AI and administrative law that is widely referenced in the field. And then finally, Gerald Chan, who is a partner at Stockwoods in Toronto, where he practices criminal, constitutional, administrative, and select civil commercial litigation at every level of court, including over 20 cases at the Supreme Court of Canada. He has been recognized as a leading practitioner by every legal ranking service known to man, and was a 2019 Canadian Lawyer Top 25 Most Influential Lawyers in Canada. Gerald is a prolific writer and teacher, most notably for Emond anyway, a co-author on Emond's Digital Evidence and Practitioner's Handbook, the second edition publishing later this year. Gerald is also the current president of the Federation of Asian Canadian Lawyers and is a member of the Judicial Appointments Advisory Committee. So thank you three for being here, and just generally, I welcome everyone to this event. We're going to hear from a lot of very interesting people. So I think first up on the agenda, we were going to talk about some fun facts from some of the contributors that are in attendance tonight. So maybe Chris, we'll start with you. Chris Bentley is the former Attorney General of Ontario and current Managing Director of the Ryerson Legal Innovation Zone and the Law Practice Program.
Well, thanks very much. Delighted to be part of this project. So wrote a chapter on online dispute resolution and the use of AI. So what does a broken boiler and a lousy fix-it job, a parking ticket, or 60 million disputes on AI have to do with anything? Well, they were the problems that 3 AI pioneers used to get to an answer. And it's all about getting to an answer. If you want a faster, simpler, more affordable answer to your problem than the current system presently provides, you're going to be going online, you're going to be going out of the courts, and I suspect you're going to be using AI, either in a systemic way or to supercharge your practice to help your client along the way. It's a fun chapter. AI is a good tool to use. Thanks.
Thank you, Chris. Maybe we'll move on to Ren Buchholz, and he's a partner at Pallair, Rowland, Rosenberg, and Rothstein.
Thanks very much. And I'm actually here with Andy Yu, who helped do the lion's share of the heavy thinking on this chapter on basically what should be the civil standard for liability when AI tools are used. And Andy is a terrific mind, and he's going to be teaching out at Western pretty soon. So we started with the the question of, okay, if these tools are going to be out there in the wild and they're going to be used by companies and individuals, what do we do when they go wrong? You know, who do we look to? Do we look to the tool makers? Do we look to the people who are wielding the tools? And Andy and I came up with, I think, a fairly elegant lens through which to examine it, which is this idea of graded agency. The idea that basically the more you hand over your agency to the tool, the more, the stricter the liability for you as an individual or as a corporation. And the chapter has some very interesting examples from where AI has been used in the real world, including in hiring, including in the medical world. And I think it's a fairly accessible way to approach, you know, a fairly complicated set of topics. And so I'm looking forward to the book being out there in the wild and to hearing from all of you out there in the world where we could have done better and how we can make the next version even stronger. So thanks very much.
Thanks, Ren. Next up, we can hear from Ryan Fritsch, who is AI human rights and health lawyer.
Hi, everyone. Thanks for including me in this. And, you know, big thanks to Jill and Jesse and Gerald for all their awesome work and putting together such a great book. I had the great fortune of being invited to write the introductory background chapter, which kind of provided a little bit of an overview of how AI is intersecting with multiple different facets and practice areas in the legal profession. And one little anecdote I turned up, I think, is a really great example of how the way we think, how humans still think, plays a huge role in determining whether AI is used for good or whether AI is used for perhaps less good. And the example I found was a risk assessment tool that's used very, very commonly in United States criminal jurisdictions to determine who should get bail. And what this thing does is it generates a risk score. What's interesting, though, is how that risk score is interpreted. In some jurisdictions, a very high risk score tells the local officials that this person ought to be put back in the pen. They ought to be locked up. They're a risk to society. But in other jurisdictions, they interpret that a little differently. They saw that risk score not as inviting more criminal prohibition, but actually as an indicator of the precarity and risk of this person in the community and the kinds of factors that are making them at risk. And so when they saw a high score, they didn't send a police officer to round the guy up. They sent out a social worker or mental health services or found the person housing. And in my introductory chapter, I called this the Officer Krupke problem. And if anyone knows West Side Story, you know that Officer Krupke is there to round up all the truant children who are running around New York in the gangs. And the children sing the song that it's like, "Dear Officer Krupke, I don't need a day in the pen. I need a social worker." So I want you to think about that as you're working with AI, because how we interpret the AI and how we implement it and how we incorporate community feedback into that, I think will play a huge and very determinative role in how this impacts rights and the justice system going forward.
Thanks, Ryan. Next up, we'll hear from Maura Grossman, who is the research professor in the School of Computer Science at the University of Waterloo and an adjunct professor at Osgoode Hall Law School.
Hi, everybody. It's great to be here. To be frank, I'm not sure there's anything funny about my chapter. It's probably one of the more technical ones in the book, but I'll give this a shot. So vetting an AI tool before you license or purchase it is really something that's critical to do. First, you want to make sure that you or your organization is able to achieve your intended goal. Second, that the tool actually does what it's supposed to do and what you need it to do, and that it does so accurately and reliably. Third, that whatever you're using the AI for is actually an improvement over your current practice. And finally, that you avoid the delay and expense of having to redo all the work you were trying to automate in the first place. So if you skip the vetting process and rely only on the vendor's demo, you should understand that those demos are often performed on clean data that's calibrated to perform really well in a sanitized demo, and that your own mileage may vary. So word of mouth is helpful, but as the old saying goes, trust but verify. So the best thing you can do is actually take an AI tool on a test run on your own data. And in chapter 13, we provide a step-by-step process for vetting an AI tool.
Excellent. Thank you very much. Next up, we'll hear from Colin Stevenson, who's a partner at Stevenson Welton and a certified specialist in civil litigation.
Thanks very much. It's been a pleasure to be involved here. The chapter I wrote was together with Jesse Beatson. Thank you, Jesse, for all your hard work on it. And our chapter was AI-enabled litigation tools and introduction. So I'm a very practical person and a practicing commercial litigator. So when I was president of the OBA, I was interested in innovation and technology and how lawyers were going to be innovative and improve our practices. So I got one fun fact and one not so fun fact. The fun fact relates to the use of AI for legal research. And I know Carla wrote a chapter on that in detail, so ours was only the introduction. But in the course of that, we thought about so all the data on the court's decisions gets put in the database, and AI coughs out a memo telling you what your juniors used to tell you, and supposedly better and cheaper. But one of the interesting and the fun facts is that in France, in June 2019, they made it illegal to do this sort of data analysis on using judges' names. Whereas here, it's not. You can feed in the judge's name and see how arguably they're going to decide your motion that's upcoming or your trial that's upcoming. And tied into the fun fact that France thinks this should be illegal, Blue Jay Legal, which is one of the leading lights in our jurisdictions here, certainly on tax law and employment law for this sort of research, they don't think the use of judges' names is useful, apparently, whereas their competitors, Loom and Westlaw Edge, do allow you to do this sort of research on judges' names. So I'm interested to see where that goes, but you're going to have a large database before it becomes material, in my opinion. So that's the fun fact, and then I'll conclude with the unfun fact, which is we also mentioned in our chapter about regulation and what the Law Society of Ontario in particular, but the Law Society of British Columbia are doing here, which is really not much of any use at all. But I'm just updating you all on something that's not in the chapter, because just in this month, the Law Society of Ontario approved its regulatory sandbox. It has a technical task force report on the topic. BC has its sandbox in place as of a few months ago. But these regulators are going to be focused on direct-to-consumer innovations using AI, and they're not going to be focused on the fact that the Ernst & Youngs in the world are spending $2 billion a year on technology and AI. So we're in for a transformation, and it's going to come sooner than we think. So those are my fun and unfun facts.
Thanks, Colin. Next up, we have Carla Swansberg, who's the VP and General Manager at Epic, which is a global technology-enabled services leader.
Thank you. And my chapter is on legal research and writing, also can be a dry topic. So I just wanted to give a quick note about one tool I mentioned that I think is quite likely to have an impact on legal research and writing, and that's called GPT-3, which is an open AI platform that's built to write predictive text. So you tell it what you need, you ask it a question, and it will give you allegedly a fully correctly written English language response. To train it, we all know about training AI. Its developers essentially fed it the internet. So purport to have trained it using 45 terabytes of data, the largest AI training set ever, much of which was Wikipedia and Reddit. So you can kind of use your imagination as to the data source there. And just as a matter of interest, GPT-3, I suspect, will have some implications for plain writing in law or drafting of legal arguments. But so far it has ended up near the top of Hacker News publications with blogs written by GPT-3. It has written an op-ed for The Guardian, which not everyone realized was written by AI. It has written a poem in the style of Dr. Seuss about Elon Musk. And in 2020, just a few months ago, Forbes named GPT-3 its AI Person of the Year. So watch for that in legal research and writing.
Thanks a lot, Carla. And then finally, we have Andy Yu, who's a judicial clerk at the Supreme Court of Canada, and he'll be joining the Faculty of Law Western in 2022.
Hi, so I just wanted to thank Ren for getting me involved. This is a really interesting topic, and the idea is all his, and I'm just his sidekick, but I was really grateful to be involved. It's a really interesting issue, and I was glad to be able to take a first stab at what I think is a very challenging problem. So I think I could have done a better job than Ren did in terms of articulating the sort of basic idea, being that the extent to which a person can be held liable for harms that AI cause depends on the extent to which they delegate decision making, whether it's partial or complete. In the case of complete delegation, we have a strict liability standard, and in the case of partial delegation, we have a standard that sort of resembles negligence. The fun fact that I would, or the other aspect to this that I would sort of try to highlight is the idea that we can sort of build on these existing common law concepts that we already have, strict liability, negligence, and adapt them to these new contexts. And as a sort of contrasting example, one kind of idea that some people have talked about is to take AI agents themselves to be sort of persons and to potentially hold them liable. So that might be a view that we might want to sort of consider more as AI becomes sort of more intelligent. But at least right now, given where AI is at, we suggest a sort of slightly more conservative approach. So we don't need to take AI's agents to be persons, at least for now. We can adapt existing ideas in the common law.
Thanks a lot, Andy. All right, so now I think we'll switch over, and I'll kind of kick this over to the general editors, who are going to read excerpts and then discuss the book generally. So Jill, over to you.
Thank you so much, Danon, and thank you so much to all of you who are attending here this evening for the launch of Litigating Artificial Intelligence with us. This book has been my obsession and my passion project, and I am so thrilled to have it see the light of day. I'm incredibly grateful to the amazing team at Emond, to my brilliant fellow general editors, Jesse and Gerald, and to all of the incredible authors. Together, we've imagined a framework for future discussion of law's growing engagement with AI. And this evening, I'm going to read an excerpt from a chapter I wrote, which is chapter 10 in the book, and it's called "Do Androids Dream of the Electric Chair? Questions about Criminal Liability for AI Agents." And as the title of the chapter suggests, the chapter considers the speculative and almost fanciful question of whether we should hold AI criminally liable themselves for the harms they commit. The chapter appears in part 5 of the book, where we're looking at AI as subject matter of litigation. So without further ado, I'll read the excerpt from the chapter. The ability to create non-human beings has occupied the popular imagination for centuries. Often these imagined creations become independent in ways we did not intend or foresee. They go rogue, become powerful, and act in ways that harm us or even threaten to annihilate us. In the Golem of Jewish lore, the Sorcerer's Apprentice, Frankenstein's monster, the Terminator, the Nexus 6 model android, the HAL 9000 computer, and countless other examples, we have imagined and reimagined what happens when we harness divine, magical, or technological powers of creation. The entities we summon into being seem like us, able to act and maybe even think, but they are not us. They may be stronger and or smarter than us, but they lack our humanity, our empathy, and our values. When they escape our control, they may resort to violence to protect themselves or seek to dominate and annihilate us. They may ultimately threaten to surpass and replace us. Literature and films are full of the creatures we have conjured using magic or technology that morph and grow into forms at once familiar and foreign, whose cunning and intelligence force humans to question our place in the universe. Artificially intelligent non-human entities are no longer exclusively the province of science fiction. We have not yet invented circuit boards or algorithms that produce consciousness, but we do have artificially intelligent computers, which are disembodied, and robots or machines, which are embodied, that exhibit impressive reasoning, computational, and pattern recognizing abilities. We rely on disembodied AI computer applications regularly when we use search engines that predict what will be most responsive to our queries, in using ride-sharing apps, in using COVID-19 contact tracing apps, and in myriad other applications. We encountered embodied AI, perhaps less frequently but not uncommonly, in robot vacuums, autonomous vehicles, manufacturing robots, military killer robots, and smart sex doll robots, among various other forms. The general artificial intelligence or conscious AI of dystopian fantasy is still likely a ways off. This means that we don't, or don't yet, have to prepare to confront machines that come into consciousness and intentionally try to harm, dominate, or simply outmaneuver humans. But the forms of AI that we do currently confront may cause serious harm or death by accident, by design or at the behest of their makers or users, or in execution of their own coded objectives, some of which may involve autonomous and unpredictable choices or actions. So although we don't yet have to suit up to wage an existential battle for humanity against malevolent machines bent on world domination, we do increasingly face the question of how best to address AI-caused harms. And the chapter goes on from there to identify the kinds of questions we as a society will have to answer in the process of determining whether AI entities can and should be criminally convicted and punished for the harms they commit. Questions like, what is AI in law? And what is it we're actually trying to do in the criminal law? Ultimately, though, the questions identified in this chapter go far beyond the question of AI criminal liability. They are fundamentally questions that echo throughout the book, through all the chapters, ones that have to inform how we, justice system participants, society, humanity, engage with AI. Questions like, what does it mean to be a moral and accountable human in society? How can and should law reflect, order, control, and enforce values in society? These are the questions, the very fundamental questions this book raises and asks us to engage with as we confront the brave new world of AI. Thanks again so much for joining us tonight.
Thanks, Jill. And now over to you, Jesse.
Thanks, Dan, and thanks to all the contributors so far too. All your fun facts were terrific. Thank you also everyone who's here tonight. Because this is a webinar, of course, I don't know exactly who's there, but I do know that I have some friends and family here tonight, and I really appreciate you being here, supporting the book, supporting me. Just really appreciate it. I'm going to read a short section from the last chapter of the book called Coda, Litigating in an Era of Thinking Software. I saw that this chapter is actually published on the SLAW law blog today, so you can read it there in full. Before I start reading, I want to briefly explore something, namely, what does it mean, thinking software? Of course, AI doesn't think like we do. Really, it is no more sentient than a floor mat so far. But unlike the floor mat, it can find relationships between vast quantities of data, and it can make connections that its human programmers may simply never have seen. Certain things it does better than us, and that's why we will increasingly turn to AI to do some of our thinking for us. But when AI is used to render legal decisions or provide legal advice, which it is, as you've heard from various speakers tonight, that's something that's novel for the legal system and something for lawyers, judges, policymakers, and for all of us to grapple with. This is something on a very different order from checking the Google Maps algorithm to see what the most efficient route is to get to work. This is something that has massive consequences that will ripple throughout society. Okay. So from a practitioner's perspective, AI is transforming what it means to provide legal services in areas such as e-discovery, contract drafting and analysis, and litigation. Lawyers in all practice areas will need to adapt and learn new skills, including data science and data literacy, to remain competent. Codes of professional conduct will likely need to be amended. AI and algorithmic competency may become a professional, ethical, and training obligation. As AI becomes more sophisticated, some consumers of legal services may eventually bypass lawyers and law firms altogether and go directly to legal technology vendors for legal advice. In such cases, law societies and other regulators may view those who create AI programs as alternative legal service providers, ALSPs. Although ALSPs are permitted in some jurisdictions, in others they are considered unauthorized practitioners of law. On the one hand, it could be in the public interest to prevent or discourage non-lawyers, i.e. software developers, from building systems that essentially act as a lawyer. On the other hand, seeking to prohibit and push out novel options for legal advice and guidance, which can facilitate access to justice, might be viewed as a self-serving attempt by lawyers to protect their monopoly on the provision of legal services. AI could, after all, empower those who cannot afford lawyers or access legal aid. Assisted by software that can digest reams of judicial precedent, court procedure, and other legal texts, self-represented parties could advance their own matters, powered by AI. Advocacy will be reassessed in our AI world. We offer this book as a roadmap to assist legal professionals in contending with existing AI and also the AI of the future. Lawyers and judges have an obligation to promote an accessible, transparent, and fair justice system. To that end, AI will bring a unique set of challenges and opportunities. For example, AI decision-making threatens to import systemic biases. Meanwhile, AI litigation tools are poised to increase access to justice and arguably democratize law. Ultimately, the intersections of AI and law call for nuanced study and analysis. Disruption from AI will transform and even revolutionize society. Beyond the justice system, the very ways in which we live and interact with each other will be affected. Impacts will be enormous, for good and ill. We are long past the birth of the information age. We are in an era of thinking software. Let's pay attention to what this means. It is not business as usual, and the stakes are high. Thanks very much, and I will pass the floor over to Gerald.
Thanks, Jesse. Over to you, Gerald.
Thank you so much to everybody for coming. Thanks to Danon and the whole Emond team, and to my brilliant co-general editors. I chuckled at the introduction because I had told myself I needed to take a break from writing until Danon told me what the topic was and who I would be working with. And then it was an easy decision from there. So this has been a fascinating journey for me, as I'm sure it has been for everybody who's involved in this project. I'm going to read a couple of excerpts from a chapter on evidence that's titled Evidence, AI in the Courtroom. Can't promise that it'll be as scintillating as the excerpts that you just heard from Jill and Jesse, but it's an extension to some extent of my thinking about digital evidence and writing about digital evidence, an obsession with how we prove matters in court when it comes to the intersection of law and technology. Although I have to say that how we authenticate text messages from flip phones, which was sort of the classic problem I was concerned with when working on my book on digital evidence, is a far cry from the types of machine learning and AI that we're now concerned with this text. So with that said, let me turn to, I'll just read a couple of paragraphs from the introduction of this chapter, as well as a couple of paragraphs from the section on authentication. Artificial intelligence is not the first novel application of science or the first example of algorithmically driven technology that has graced our courtrooms. It is, however, the first of its kind and in a class of its own with respect to technical complexity and its potential impact on the administration of justice. Although the law will always lag behind new technologies, the time is now upon us. Modern litigation practice will increasingly require practitioners and jurists to understand the uses and implications of AI-based tools in myriad contexts, including policing and criminal justice, intelligence gathering, the regulatory state, and private industry. The law of evidence lies at the heart of this exercise. Authentication, admissibility, and advocacy are the bread and butter of evidence law. Adapting those traditional legal principles to address novel technologies is the challenge to which our jurists and legislators must rise. We know that AI can forge or distort data that are stored on a device or published online. Can AI meet the robust standards that we have set up through the hard-learned mistakes of the past for the admission of novel science and expert opinion evidence? Can the law of first and third-party disclosure address the predictable calls from counsel for the source code or provide a functionally equivalent way to assess the reliability of an AI-related tool? What about the law of civil discovery? And what role do public interest privilege and third-party interest play in the assessment of a party's legal or constitutional entitlement to access proprietary information for the purpose of litigation? Let me just skip ahead a few pages now to read a couple paragraphs from the section on authentication and the best evidence rule. The first step in admitting any sort of electronic evidence is generally authentication. Authentication is often taken for granted with physical evidence, but the digitization of information has made it easier for data to be altered or doctored. As one judge put it, electronic documents are much more malleable than ordinary documents. Such documents will become even more malleable in the age of AI. In June 2019, a couple of artists posted a fake video of Mark Zuckerberg to Instagram. The video depicted Zuckerberg talking about amassing power and control through a nefarious organization called Spectre. But this was not your average photoshopped work. This was a sophisticated video created using a suite of machine learning and AI techniques that allow for the manipulation of visual data, specifically the movement of bodies. So much for video footage being the constant, unbiased witness with instant and total recall of all that it observed that the Supreme Court of Canada described in Nikolovsky. These types of altered videos and images are commonly referred to as deep fakes. They are terrifying in their realism and becoming increasingly prevalent. As the authors put it in one report, with thousands of images of many of us online in the cloud and on our devices, anyone with a public social media profile is fair game to be faked. How can we ensure the integrity of electronic evidence in the age of AI and deep fakes? And these excerpts for me underscore one of the most challenging, among many challenging problems with AI when we think about how this is going to be played out on the ground in litigation in our courtrooms. And the authentication example, I think, is one of the more interesting examples, because when we think of the law of authentication as it stands right now, the threshold is not high, and the law states that the party proffering the evidence does not have to negate through evidence all concerns of tampering unless there's some air of reality to the notion that the evidence has been tampered with. To what extent can that approach persist as we confront increasingly sophisticated forms of AI that can, as said in the chapter, distort data, that can have positive as well as negative effects? And what would the alternatives be? Are we going to move to a regime where we do impose some additional burden on the party proffering the evidence to negate concerns of tampering? And if so, what does that mean for access to justice if we are going down the road of insisting that expert evidence, for example, be routinely called in order to authenticate this evidence to be even admitted in the first place? I think that underlying tension is an interesting one, certainly to my mind, and one that we explore further in the chapter on evidence. Thank you for listening, and I thank everyone for attending.
Thanks so much, Gerald. All right, that's sort of the formal part of the launch. Now we're going to have a Q&A. So for all the attendees, feel free to ask questions. You can direct them at a particular panelist, or whoever wants to pipe in will do so. So the floor is open for questions.
And for those who haven't used Zoom before, if you just go to the very bottom of your screen where it says chat, you can type in your questions and our panelists will be able to answer accordingly.
Looks like we answered all the questions. All right, here we go. So this is from John Duffy. Where is the judicial branch of government on AI relative to the legislative and executive branches in Canada? Anyone want to take that?
I mean, I'll jump in. I'm not sure I understand the question. One of the things that I talk about in chapter 10 is the fact that there isn't a ton of law explicitly dealing with artificial intelligence yet. And most of the places in which we see AI referred to, it's used by way of analogy. In chapter 10, I talk about how, artificial intelligence is, or robots are talked about as a metaphor for being a zombie, not having any volition, not having any will. And so the prevailing judicial view of artificial intelligence seems to be that to be artificially intelligent is to be zombie-like, to have no will, to have no agency. And in reality, that isn't completely accurate and not completely representative of the prevailing state of technology now. We know with machine learning that a lot of machine learning, artificial intelligence is emergent, that it is unpredictable. Yes, it acts according to programming or according to code, but it does so in ways that may be unpredictable or unforeseeable by humans. The current sort of apparently prevailing view of artificial intelligence in the judiciary in Canada today is one that is maybe a little bit out of step with the technological reality. And one of the things that gets argued in chapter 10 and in other places in the book is, if we're going to have a law in this country that's not out of step with the technology, all branches of government and all justice system participants are going to have to get up to speed and are going to have a view of the technology that's more representative of the reality of what these technologies can do now.
Can I just add something to that? Or should we move on to the other questions?
No, please do.
I was going to say that I agree with everything that Jill has said, and also I would add that in other areas where the law has had to deal with new developments in technology, one of the big questions they have to answer as they go forward, and when I say they, I mean the judiciary and also the legislature, is do we need to have technology-specific rules or do we need to have technology-agnostic rules? So for example, is it possible to craft a rule of general applicability, because of course there's going to be a slippage between the development of the law and the development of the technologies that the law is meant to govern. And I think that tension is really going to become apparent in this realm as it has been in, for example, the intellectual property or the internet realm, where so wiretaps are a great example. We've been applying wiretap jurisprudence to technologies that don't really have wires, and you don't really tap them in all kinds of settings. And so looking for ways to encourage the judiciary, encourage policymakers to think technology agnostically while still having it be applied to these specific technologies usefully that they're dealing with, I think is a real question or a real challenge for us today.
Thanks a lot. All right, next we've got a question from Kenny Handleman. Who is currently setting the definition regarding what constitutes AI, and how often would it be updated moving forward? Also, would the definition regarding the sentience culpability of an AI model be set by its creators as it evolves, or by the judiciary, who should decide what bars to set for any sort of regulation prosecution?
I can take a stab at the first part at least. So the definition of AI is really something that is in flux. It's something that different people have different definitions, and one of the challenges is that there isn't a standard-setting body, some kind of international coalition that says this is what AI is, and then lawmakers and the judiciary can simply apply that definition. And in fact, we talk a little bit about in our introductory chapter about how, in some sense, AI is a cultural construct to describe a set of technologies that are kind of currently impressive and beyond our comprehension. So, things that were AI in the 90s, because the term AI has been around since, I believe, the 1950s. But the things that were described as AI in the 90s are certainly not considered AI anymore. One of the most impressive AIs ever created at the time was Deep Blue, which challenged chess master Garry Kasparov and defeated him. And that was a major watershed moment. But at this point, we consider Deep Blue as kind of a giant calculator, right? It's far from the machine learning, deep learning technologies that we now have. So just to say that is one of the challenges we face. That there are some working definitions of AI, but there's no standard setting body that says exactly what it is, and the definition is a little bit slippery as well. And I'll leave the second part of the question for any of the other panelists.
Yeah, I'll chime in briefly on the second part of the question and try to do so in a not so jumbled way, even though my thoughts on it, I think, are a bit of a sort of messy clump in my head. But I just sort of building on what Ren said earlier about needing to think sort of beyond technology specific rules, because there always is slippage, there always is a lag between the law and technology. And if you want a great example of that, I mean, you don't have to look any further than the case of Fearon, where the Supreme Court of Canada decided not that long ago when the police can search a smartphone, and the facts that grounded that case was the search of a flip phone that had no smartphone capacity. So that's how long it takes the courts and the law to sort of catch up with the current technology. And so I think you need to think at a higher level of generality. At the same time, you can survey the existing legislation on how we regulate the admission of evidence in a courtroom. And to go back to the authentication provisions I talked about earlier that are in the Canada Evidence Act, those provisions, many have argued, are ill-suited to govern the authentication even of sort of, fairly pedestrian digital evidence like text messages and social media sites, because those provisions really are about, is the computer hardware malfunctioning? Right. And if you look at those provisions, they're all about, if the computer's working properly, then anything the computer spits out is sort of necessarily authentic, as opposed to being concerned with more sophisticated forms of tampering. So forget even AI. I mean, you have sort of our existing legislation, which is outdated and ill-suited for the challenges that pedestrian forms of digital evidence present, let alone the more sophisticated challenges that we're going to see as we enter into machine learning and AI, which is several orders of magnitude removed from what we're seeing now. And so I don't know that answers the question so much as it, I think, highlights some of the challenges that we're going to be facing.
Damien, can I just add something to that? In chapter 6 of the book, we do talk about how AI is challenging law and in many ways revolutionizing law. And one of the things that we're talking about is some of those practical challenges that Gerald alluded to. How do you deal with how quickly the technology evolves and how slowly the law evolves, and kind of the mismatch between a common law system that evolves slowly, incrementally, in a precedent-based way, applying past precedents to new specific situations. How do you deal with the mismatch between that and the very rapid, move fast and break things, exponential evolution of new technologies? And so I don't think we have good answers for this yet, but it's certainly something that we're really grappling with the book. And we're asking, how does the common law accommodate this new technology? Does the law have to be radically rethought, or do the technologies have to be kind of brought to bear so that they are properly within a rule of law bound world that works within our legal system?
Thanks, Jill. We'll just take a few more questions. There's actually 2 questions on how AI impacts the practice of law. So one is from Elke Handleman. How long approximately until we get to the point where clients, before retaining a lawyer, will know enough to ask whether that lawyer uses AI in their activities providing legal services? And the other question is basically, what would be the best ways that AI could help lawyers practice law?
Well, perhaps I'll just comment on the latter, seeing that's in my bailiwick. In terms of how AI helps us now, the most obvious one is certainly for litigators is computer-assisted e-discovery. I mean, 10 years ago, if I got 1 million documents in a class action, you'd be talking about hiring 30 juniors over a summer to go through them all, and they'd be forever damned and never practice law again, having suffered through that misery. But now you find assuming you can easily identify 10, 100 pertinent documents, AI will now go through the 1 million documents and find ones like it without you having to do much searching of your own. Obviously, you review the 3,000 you end up with, but it's an amazing development for class action lawyers, for lawyers dealing with huge database of documents. So that's an obvious one. But I think what's more interesting for us to think about is how the practice of law is going to change as AI comes into the system, because there's going to be a different type of practice. And the example I look at is if you've got, and this is the large law firms have this sort of thing, if you've got a significant sized clients who have repeated questions like mortgage enforcement, debtor creditor relations, you can work with the AI people to come up with a system to deal with complaints or enforcement procedures, so that you don't need to have a large department of lawyers dealing with these repetitive and relatively small disputes. So I assume all the large law firms are already working on these types of developments. Now, AI itself hasn't taken off yet in that area, but it certainly will. So it's not, my point is that ultimately AI is helping us now, but it's going to help us in ways that really aren't even developed. It's going to change the practice of law. Where we are in 10 years from now will be a completely different type of practice. And certainly, the bespoke high-end stuff may well be the same. The senior high-end counsel work will be very similar, but the large bulk of repetitive types, uncomplicated actions are going to be transformed by the use of AI, in my opinion.
Thanks, Colin. Well, we are running short on time, so maybe we'll go to our giveaways. So we've got some questions here. So everyone can just respond in the chat function, and everyone who gets it right will be put in a draw for various items. So for the first one, it's a coffee card. And the question is, what computer scientist is often cited as the father of artificial intelligence?
How about we all simultaneously count to 5, and we'll give everybody 5 seconds to type it into the chat, and we'll enter everybody in, okay? So 3, 2, 1, let's start counting. 1, 2, 3, 4, 5. Okay, that's it, everybody.
So the correct answer is John McCarthy. We've got some Alan Turings and Jeffrey Hinton, but John McCarthy is the right answer. Next up, this is for some Emond swag. It's a candle. What 1990s robot was an experiment in effective computing? That is, a machine that can recognize and simulate emotions through human body language and voice tone.
All right, 5 seconds, everybody. 1, 2, 3, 4, 5. Teddy Ruxpin. Okay, we'll give you a little more time if someone wants to Google this. I know this was a little tricky. So again, the question is, what 1990s robot was an experiment in effective computing? And effective computing means a machine that can recognize and simulate emotions through human body language with voice and tone.
Oh,
Okay.
There we go.
Yes, the correct answer is Kismet. Oh.
Nice.
Okay.
Job, Evan.
All right. Well, then you both get a candle.
Exactly. All right, the final question. This is for a free copy of the book. What is the first law in Asimov's 3 laws of robotics?
1, 2.
Yeah. This has to be more than 5 seconds.
Yeah.
Yeah, this is a tough one.
Yeah, this is a tough one. It's a long answer. So yeah, please, more than 5 seconds.
Yep.
Ah, interesting.
That's correct.
Well done, everyone. Officially, a robot may not injure a human being or through an action allow a human being to come to harm.
Do you want to read the other 2, Dana?
Sure. The second law is a robot must obey the orders given it by human beings, except where such orders would conflict with the first law. And then the third law is a robot must protect its own existence as long as such protection does not conflict with the first or second law. All right. Thank you, everyone, for participating. And that pretty much brings our launch to a conclusion. Again, you can, we'll put the link to the catalog page again in the chat with the discount code. And I'd just like to thank all of the panelists for contributing to the book and helping out tonight, and for all the attendees for attending. It's been a real pleasure.
Thank you,
everyone.
Thank you, everyone.
Thanks so much.
Bye-bye.
Thank you.